Welcome to Course 3, where we're going to talk about marijuana licensing. Now, in the previous classes, we talked about history in Course 1 and Course 2. We talked about the difference between marijuana and hemp. In this session, we are going to specifically talk about marijuana. Forget about hemp for today. Right now, what we're focused on is marijuana. Now, a hemp license, very non-competitive, not hard to get, and as an attorney, you're not going to charge your client very much for a hemp license. Now, a marijuana license, on the other hand, is extremely hard to get, and as a result, when you get one of these marijuana licenses, they're extremely valuable. So as an attorney or as a consultant, you're able to charge a good amount of money for drafting one of these very, very competitive applications to get one of these marijuana licenses. So essentially what you're gonna need to understand, what I say is it really boils down to these items on this board if you're looking to get a marijuana license. So before you even start drafting your application, you need to be checking the box on all these things. So the main 4 things, number 1, you have team. You need to have a team that's experienced, diverse, and residency is important too. Now, some states have a residency requirement for ownership that's been challenged in the courts, but residency is very important because what the scorers want to understand is they want to know that this is a local. This is a team that's from here, not some California team that's applying in Florida. They want it to be Florida individuals. They want to make sure that they're diverse, and they want to make sure that they're experienced in growing marijuana or dispensing marijuana or processing marijuana, depending on whatever license you might be going for. The second thing is compliance, and this is why it's very important, I think, that you work with an attorney. When people are applying, there's a lot of consultants out there, some attorneys draft applications, and I think it's fine. There's some consultants that are very, very good at what they do, but it's also important that if you do hire consultants, that you also have a lawyer that's able to really make sure that everything is compliant. And when we're talking about compliance, we're talking about social equity to the extent that you're in a state that requires a social equity applicant, residency sometimes if that's a requirement, financial and operational. So there's certain requirements in some states that you have a certain amount of capital, financial, that demonstrates that you're capable of operating one of these companies. You also want to show that you have a business plan that's compliant with what the requirements are. For example, if you're applying for a craft grow license in Illinois and you're only allowed 5,000 square feet under canopy, you need to make sure that your operational plan is 5,000 square feet under canopy. If the state requires certain things from a security perspective, you need cameras, you need security guards at your location, you better make sure that your business plan is in compliance with the law. Now, the third thing is impact. And what I mean by impact is I'm referring to diversity, community, and environmental. All 3 of those aspects are pretty much important in every single state. Now, each state has different scoring parameters, so it may come up differently in different states, and it might be graded a little bit differently, but these are really key things to be looking for. Lastly is execution ability. I will tell you, here in Florida, a lot of people obtain these licenses in Florida and they sat on those licenses because either they didn't have the capital to fully execute on the plan, they didn't have a good plan in place, or some of them just simply wanted to sell their license. So when someone's scoring, when the scoring team is looking at your application, they want to know that you're able to execute, and that means having the financial capability to execute, but also the operational ability to execute. So when you're building your team and you're planning out how to apply for a marijuana license, my recommendation is to really keep all of these things in mind. So what we're going to do is now we're going to go through, before we get into the specifics of some of these marijuana licenses, we're going to talk a little bit about the difference between a horizontal license versus a vertical license. So in essence, what we're referring to here in a horizontal license, that means that you're applying for one specific license for one activity. For example, you're applying for a cultivation license, or you're applying for a processing license, or you're applying for a dispensing license, or you're applying for a delivery license, right? Vertically integrated license means that that one license allows you to do everything in the supply chain. Right now, the only state that requires vertical integration is Florida. When you have a Florida license, you not only are allowed to grow, process, dispense, and deliver, you're actually required to grow, process, dispense, and deliver. So Florida has a vertically integrated license. Just one license allows you to do the whole supply chain, requires you to do the whole supply chain. Every other state is essentially a horizontal structure. Now, even in those horizontal structures, in many of those states, you can apply for each one of those licenses and ultimately have a vertically integrated company. So you could apply for a grow, apply for a processing, apply for a dispensing, and apply for a delivery and be able to do the entire supply chain. But that's very different than the Florida framework that actually requires vertical integration. Now, some states, such as New York, that just came out with their regulations, they actually don't allow for their recreational market, they don't allow a fully vertically integrated license. So what they say is that if you own a retail license, you cannot also own a manufacturing or cultivation license. You could own a cultivation and manufacturing license, but you can't also own a retail license. So very important that you really look at each state law. When you are planning out how to structure this, you want to figure out, are we going after all of these licenses, or are we just going after one particular license? Because if you're just going after a cultivation license, the team with the experience is going to be much different than if you're going after a dispensing license. Now, like I mentioned, here in Florida, you got to do the whole entire supply chain. So if you're applying here in Florida, your team, you need to demonstrate that you have the experience to cultivate, process, dispense, and deliver. So in Florida, you don't have any choice. Your experience needs to go all across the entire supply chain, whereas in these other states, you will have the option to apply for a particular license. So moving on to the next slide, what I want to make a distinction on here is the medical versus the recreational model. So in a medical world, you have licensed doctors. Now, as an attorney, you may represent doctors. I represent one of the largest franchises here in the state that have marijuana clinics. And so there's certain requirements as far as being a doctor that's allowed to write recommendations for qualifying patients. So in the marijuana framework, it's really there's certain specific qualifying conditions, and if someone has those qualifying conditions, they can then go see a doctor. That doctor, if they have those qualifying conditions, can then give them a recommendation for a medical marijuana card, and once they have that medical marijuana card, they could essentially go and they could acquire medical marijuana at a medical marijuana dispensary. So in the medical side of things, what you see is less differentiation in the products, and you're generally going to see less pizzazz when it comes to the marketing, right? It's not meant to be recreational. It's meant to be medical. It's kind of boring. We're not marketing to the masses. We're actually providing a medical product. Recreational, on the other hand, you're going to see that the labels and the marketing has a lot more excitement. They're trying to market to the masses. Now, from a demographics perspective, in the medical markets, what we're seeing that it's mainly 35 plus, and in the textbook we provide a lot of charts and graphs, and if you're applying for a license, you want to build out your business plan based on those demographics. So if you're applying for a medical marijuana license, you're going to want to explain in your application how you're targeting those particular demographics versus if you're applying for a recreational license, you're going to want to explain how you're targeting maybe a younger demographic from 21 to 35. Now, regardless of whether medical or recreational, both laws are very specific about not marketing to minors. So you're never, ever going to want to market to minors. In fact, the Florida rules that just came out for edibles specifically don't allow you to have any edibles that even resemble an edible product that's out on the recreational market. So really a lot of this is geared towards not marketing towards minors and really keeping this 21 and over. But the recreational market versus the medical market is very, very different frameworks, and you're going to want to tailor your application depending on whether you're in a medical framework or a recreational. Now, the states that have recreational also have medical frameworks. So you could actually decide whether you want a medical cultivation license or you want a recreational cultivation license, and very different stuff is going to be in the application depending on which license you go through. So let's move on to the next slide, and this is where we're really going to move into the gist of the application process. So generally what these processes look like is that the statute will be passed. Generally, there's either a constitutional ballot measure that allows medical or recreational. Then there's a statute, the legislator passes it, and then that statute usually delegates authority to some agency to oversee the marijuana program. So in the medical marijuana context, it's usually the Department of Health, right? The Department of Health is who oversees in most states any health stuff. In the recreational side, it's various different departments could potentially be overseeing it. Oftentimes, it's the same department that oversees the alcohol consumption. So if whatever department oversees alcohol will generally be the department that also oversees the recreational framework. So once you have the statute passed, let's say it's a medical market, it then delegates authority to the Department of Health to essentially come out with rules and come out with an application process. So that Department of Health is going to come out with their rules and their application process and their application questions and how they're going to be doing the scoring. So very, very important as an attorney, you want to go right to the statute, right to the rules, right to the application, and you want to be very, very cognizant of how they break down that scoring. For example, in Illinois, 20% of the points were allocated to social equity applicants. So applicants that 51% ownership and control was by someone who satisfied the social equity part. So if when you applied for a license out in Illinois and you didn't understand that price, that scoring distribution, and you didn't apply with a social equity applicant, you literally had no opportunity to win a license because you just gave up 20% of the points. So understanding that scoring breakdown is extremely, extremely important because it's going to be very, very competitive in whatever states you're in. So the application is going to consist of multiple exhibits. So the exhibits are going to be everything from labor and employment experience, your staffing plan, so who's going to be on your team, what the managerial hierarchy is going to be looking like, the operating procedures, so if you're a cultivator, what's your methodology for harvesting, how are you drying it, who are you sending it to extraction. All of those things are going to have to be in your operating plan. You're going to have a security plan, probably going to show the overlay of where your cameras are going to be located, what our security guards will be there. Are you going to have a vault? And by the way, each of the states have their own requirements and laws as it relates to security. So you want to make sure when you draft out your security plan that it is 100% consistent with the security regulations in the law. Some are even also going to require that you buy real property. There's going to be security overlays. You're going to want a business plan where you talk about your marketing and the demographics and the type of products you're going to be selling, and then an environmental plan and even a local community impact plan. So all of these plans we discuss in great detail in the textbook. So really, if you really want to nail each one of these topics, make sure you reference that textbook and you read through it extremely thoroughly so you understand not only what some of these laws require, but also the history and why they're asking for some of these things. For example, from a security perspective, one of the big challenges in the industry is that because marijuana is federally illegal, you're dealing with cash. It's a cash business. Because you're dealing with cash, there's a high likelihood for theft, right? If you're running a dispensary and you're making sales of several $100,000 a day or $1 million a day, you have to carry that cash. So therefore, a lot of the states require that you have a vault, right? So there's a reason behind these requirements, and it's very, very important that you understand the reason behind some of these requirements. There's also, like I referenced in a lot of them, minimum capital requirements. So you want to make sure that not only have a team that could pull this all off and have a good plan, but you also want to make sure you could demonstrate that you have the financial ability to actually pull this off. And then lastly, I want to talk about the real property consideration. So some states require that you actually have the property beforehand. Some states don't require that. So for example, in Illinois, for a retail license, they didn't require that you actually own the real estate. You just had to identify which particular geographical region within Illinois you were going to be, and you also had to provide a drawing, pretty much a generic drawing since you didn't actually have the property yet. However, on the cultivation side of Illinois, they actually wanted you to identify an address. And when they issue that license is specific for that address. So what does that mean? It could be very expensive because you're essentially entering into either leases or letters of intent to essentially acquire that real estate. So what a lot of people do, and usually landlords are flexible on this, is they'll enter into an LOI that is conditional on you actually obtaining the license. So you'd enter into a letter of intent. It would say, here are the terms of our lease or me buying your property, but all of this doesn't occur unless I'm actually awarded the license. If I'm not awarded the license, then the contract is automatically terminated. So really, real estate comes in over here. You want to show your ability to execute. So not only do you have the financial ability, but you also have the operational ability, and having a good facility that's within a municipality that is okay with these types of operations is also very important. So one thing I'll just add there is that you have the state law, but what many states allow is they allow the municipalities to opt out of allowing certain activities. So for example, in Florida, you have Florida Statute 381.986 that preempts the cities from doing anything on a cultivation and processing. Not anything, but they can't outlaw cultivation and processing. But what the Florida statute allows municipalities to do from a dispensing perspective is they could either do one of two things. Either they allow them and they treat them exactly like pharmacies, or they ban them. And so a lot of municipalities within Florida have actually decided to ban dispensaries. So if you are applying for a license in Florida, a vertically integrated license, and you want to identify your locations that you'll be dispensing out of, you want to make sure that you check with local law and make sure that you're not putting a dispensary in there in a municipality that's actually banning them. So that's a very, very important key point that's really starting to become even more and more important as more states roll out medical and recreational. The municipalities are having more and more of an influence on where and whether they're allowing dispensaries within their particular municipality. So social equity. This is extremely important in the industry. In the cannabis industry, we went through in class 1, there was a long, long history of essentially people being arrested. And so there were certain communities that were really disproportionately impacted by this war on drugs. So what you see is you see a lot of states coming up with social equity programs where they're trying to right the wrongs of history, and they're trying to basically give preference to those communities that have been disproportionately impacted by the war on drugs. And Illinois, like I mentioned before, 20% of those points were allocated to social equity applicants. So in essence, unless you were applying in Illinois as a social equity applicant, you really had no chance of winning. So it's very, very important you understand the social equity aspects and the point breakdown in each of your state. California also has a social equity program. Many of these states have like actual social equity programs. Florida does not have a specific social equity program, but they do have certain provisions in there that basically give additional points for if you have diversity and inclusion and stuff like that. So even for states that don't have an actual social equity program, you're still really going to want to focus on social equity and diversity as you're building out your team and kind of rolling out your plan. not just because of the point system, but also because it's just the right thing to do, right? We have an opportunity to create a industry really from scratch. This is a brand new industry. So let's try to get it right. Let's try to make sure diversity and inclusion are at the forefront, not just because it's required in the statutes, not just because you get more points in the scoring, but also because it's just the right thing to do. And I believe a more diverse workplace is a more effective and efficient workplace as well. So I think that's always a very important aspect of any applications you're doing. So on the next slide, what we're going to talk about is corporate structure. We're not going to spend too much time on this. In the textbook, there's a ton of information on corporate structure. But when you're creating your team and your compliance and the impact and your execution ability, when you're planning all this out and you're going to do your application, one of the first things you're going to need to do is you're going to need to form a company. You need to know if you're going to be an LLC, a C Corp, or an S Corp. There's certain tax implications, there's liability implications, and it really depends on your specific facts and circumstances. For example, if you're planning to take your company public and you want to create a big multi-state operator and go take that company public, most likely you're going to want a corp. You don't see LLCs going public. But if you want this to be more of a closely owned business and you just want to keep it within 2 to 3 owners, you'll probably want to do an LLC, a lot less formalities and requirements when you're creating that. So really, as an attorney, you want to discuss those different aspects of it with your client and make sure that from the very start, they're having the right corporate formation with the right documentation. So going to the next slide, what we have is the challenges on the denial of a license. So really good application drafters are not only drafting an application to win, they're also drafting the application so that they could probably sue if they actually are denied. And we're seeing this in every single state that has rolled out a program. You're seeing lawsuits just flowing in. Right now in Illinois, it's just crazy. They announced the top people that made it to the next round, and the people who didn't make it ended up suing them. So then the court system said, okay, we're going to hold off on awarding those licenses to the people who we put in that top classification. And then they ended up suing. So now Illinois is getting sued from all directions. Here in Florida, we originally had an application process in 2015. That was the last application process we had. And at the time, they only awarded around 5 licenses. Currently, there's 22 licenses. So those other 17 licenses were all issued through court cases. So in essence, what has become a very, very important strategy for obtaining a license is not only having a winning application, but also in the event that you have a losing application, setting yourself up to be able to sue the state so that you could also win. And so I go through a lot of detail in the textbook of some of the different court cases, some of the different strategies there, but it's very important as you're planning all this out and you're drafting your application that you put together a good litigation plan just in case you aren't to win a license. On this slide, we're going to talk about the do's and the don'ts. So do use this information to really think about all the documents you're going to need to gather about the owners, the business, the property, and the operations during the application process. It is highly, highly document heavy. You're going to have probably maybe thousands of pages, definitely in the hundreds of pages, but potentially even thousands of pages you will need to submit. So make sure you really use the materials we're providing to understand what documents you need to collect. Don't forget that the application process is ultra competitive. You want to try to get every single point. I've had clients that have said, oh, well, maybe we just don't get those points. We don't need to check that box. No, you need to try to check every single box or else don't even bother applying. Do use the considerations to draft operating procedures based upon the type of business and the type of marijuana industry you intend to operate in. So it's very important to know whether you're in a medical or recreational, horizontal, vertical. If you're applying for a cultivation, processing, or dispensing, you really want to keep that in mind and make sure you tailor your application for that particular issue. Don't forget that marijuana operations will be different across each state. So just because you applied for a license in one particular state with a certain cultivation plan don't think you could use that cultivation plan in another state. Each state has its own laws and regulations, and you really want to be very specific. Do use this information to think about what type of corporate structure you want to have for your client, and really put into consideration all the facts and circumstances, future, present, and the past. Also, don't just go into operations without really talking to your client about what structure is ideal for them. You'll find that sometimes your clients, they think that they're just going to be applying and not raising capital and going public. But once you start asking them questions and pushing them, you start to realize that their real plans are much different than what they maybe originally thought. So really, you got to make sure that corporate structure from the very beginning is set up properly. So that's the entire class. The marijuana licensing, very, very important for your business as a lawyer. Very, very important for you to be fully capable of doing this. Go back, read the textbook in detail. Lots of good information in the textbook. And we also have really, really good templates that we've provided as well. Thank you so much for joining, and I'll see you in the next class.